Mr. Chair, we are live.
Okay, thank you. I'd like to call this meeting to order. Welcome to the April 27th, 2001 meeting of the City of Greenville Historic Preservation Commission.
Mr. Chair, we are live.
Did anybody else hear that? I just heard a replay of Taylor saying we're live again.
I closed it out. So
Okay. Technology. Welcome to the April 27th, 2021 meeting of the City of Greenville Historic Preservation Commission. My name is Jeremy Jordan. I'm the chair of this commission. I'd like to start by acknowledging that we are conducting this meeting using a remote electronic platform. This is a remote meeting of the Greenville Historic Preservation Commission. I'd like to ask for your patience today as we proceed. There may be slight delays as we transition between speakers, participants, and presentations. The Greenville Historic Preservation Commission is a quasi-judicial body that is governed by North Carolina General Statutes and the city's Code of Ordinances. We conduct evidentiary hearings on requests for certificates of appropriateness for properties located in the Collegeview Historic District and for local landmarks. Before we begin the evidentiary hearings on tonight's agenda, I'd like to provide some important information about the steps taken to ensure that each party's due process rights are protected as we proceed in this remote platform. First, tonight's meeting will be conducted by simultaneous communication in accordance with the newly enacted statutes in Session Law 2020-3, which allow for remote meetings and quasi-judicial hearings during declarations of emergency and additional requirements regarding notice and the opportunity to be heard. Second, each applicant on tonight's agenda was notified before being placed on the agenda that this meeting would be conducted using a remote electronic platform. Every applicant on tonight's agenda has consented to the commission's conducting the evidentiary hearing on their request using this remote platform. We will also confirm today at the start of each evidentiary hearing that the participants in the evidentiary hearing consent to the matter proceeding in this remote platform. Specifically, notice of tonight's evidentiary hearings was provided by mail to all property owners within 250 feet of each subject property. The mail notices were sent 2 weeks in advance of the meeting date and within the law to provide such notice, and each notice letter notified the recipient of the remote meeting platform. No case is proceeding today in which the city has been contacted by an individual who objects to this meeting being heard by way of a simultaneous remote meeting platform. Notice was also provided by the posting of a sign on the side of each property, publishing of a notice in the newspaper, and providing notice on the city's website. Each of these notice methods were also done within the legal requirement to provide such notice. The notices for tonight's meeting contain information about the means by which the public can access the remote meeting as the meeting occurs. Third, any individual wishing to participate in tonight's evidentiary hearings was required to sign up prior to the meeting to participate. Information about the sign-up requirement, along with information about how to sign up to participate, was included in the mail notice letters sent to each property owner within 250 feet of each subject property. This information was also included on the city's website. No case is proceeding tonight in which anyone contacted the city to voice an objection to a request for the remote meeting platform. All individuals participating in tonight's evidentiary hearings were also required to submit a copy of any presentation, document, exhibit, or any other material that they wish to submit at the evidentiary hearing prior to tonight's meeting. All materials that the city received from the participants in tonight's cases, as well as the copy of city staff's presentation and documents, were posted online on the city's website at greenvillenc.gov. All materials that will be discussed tonight can be viewed at any time during tonight's meeting by going to the city's website and clicking on the link at the top left, at the top of the page for tonight's meeting. All decisions of this commission are subject to appeal of the Board of Adjustment. Finally, all individuals who sign up to participate in an evidentiary hearing on tonight's agenda have signed a notarized oath form. And now can we have the roll call?
yes, sir. Jeremy Jordan.
Here.
Candace Pierce.
Here, this is Candace Pierce.
Andrew Moorhead.
Here.
Israel Mueller.
Here.
Myron Casper. You're muted.
Myron, you're muted.
Here.
Thank you. Roger Kammerer. Scott Wells. Here. Justin Edwards.
I'm here.
Carrie Carlin.
Here.
Robert Wright.
Here.
Mr. Chair, we have a quorum.
Okay, thank you. I would like to note that Roger attempted to be with us, but the reason he's not here is because of technical difficulties. Do you have any additions or deletions to our agenda for tonight?
No, but I'm hearing a lot of reverberation from somebody who's not muted. So I would recommend whoever's not speaking to probably mute their computer.
All right, if we don't have any additions or deletions, do we have a motion to accept the agenda as written?
I make a motion to accept it.
We have a motion by Mr. Mueller. Do we have a second?
Second.
We have a motion by Mr. Mueller, seconded by Mr. Edwards. Can we have a roll call vote, please?
Yes, sir. Jeremy Jordan,
Aye.
Candace Pierce,
Candace Pierce, aye.
Andrew Moorhead,
Aye.
Israel Mueller,
Aye.
Myron Casper,
Aye.
Scott Wells,
Aye.
Justin Edwards,
Aye.
Carrie Carlin,
Aye.
Robert Wright.
Aye.
Mr. Chair, the motion was approved unanimously.
Thank you. That takes us down to approval of the minutes. Has everyone had a chance to look at the meetings from the March 23rd meeting? And if so, are there any questions or concerns about those minutes? If not, is there a motion to accept the minutes as written?
Candace Pierce moved to accept the minutes as written.
We have a motion by,
Second.
is there a second?
Second.
Second.
I think we have several seconds. I heard Ms. Wells. Can we have a roll call vote, please?
Yes, sir. Jeremy Jordan,
Aye.
Candace Pierce,
Candace Pierce, aye.
Andrew Moorhead,
Aye.
Israel Mueller,
Aye.
Myron Casper,
Aye.
Scott Wells,
Aye.
Justin Edwards,
Aye. Justin.
Very-
Aye.
Carrie Carlin,
Aye.
Robert Wright.
Aye.
Mr. Chair, the motion to approve the minutes was passed unanimously.
Thank you. That takes us down to new business, and I believe we'll have some words from our attorney before we go forward.
Good evening, Mr. Chairman and members of the commission. Pursuant to Chapter 160D of the North Carolina General Statutes, particularly NCGS 160D-406 and Article 9, Part 4 and Section 4H of the Historic Preservation Commission's Rules of Procedure. Conflict of interest. No member of the Historic Preservation Commission shall participate in either the discussion or vote on any certificate of appropriateness in any manner that would violate the affected person's constitutional right to a fair and impartial decision maker. Prohibited conflicts include but are not limited to a member having a fixed opinion prior to hearing the matter and not willing to consider changing his or her mind, undisclosed ex parte communications with the person before the commission, any witnesses, staff, or other commission members, a close familial, business, or other associational relationship with the affected person, or a financial interest in the outcome of the matter before the board. On any other matter before the commission where such decision by the commission shall be in advisory capacity only, no member shall participate in the discussion or vote on any such advisory matters where the outcome on such matter being considered is reasonably likely to have a direct, substantial, and readily identifiable financial impact on the member. Decisions on either a request for recusal by a member or objections by a person appearing before the board shall be decided by a simple majority vote. A member so disqualified will not be counted or included in the count to determine the appropriate voting majority for the issue before the commission and will not negate a quorum of the commission. As a reminder, as members of the commission, conversations among yourselves during the discussion periods of this meeting and your committee meetings are not ex parte communications. If a commission member has had an ex parte communication, that needs to be disclosed at this time. And additionally, because we are having, this is a remote meeting and we are hearing major work COAs, there'll be a couple of preliminary matters that will need to be discussed once we actually get into those, Mr. Chairman. So just wanted to make sure everybody's aware of that.
Thank you. And if I miss something, please jump in and stop me. Does anyone have anything they need to disclose at this time? If not, I'll go ahead and start reading some of the housekeeping stuff before we get into the actual COA discussion here. In accordance with North Carolina General Statute 160A-400.9, City Codes 9-7-12 to 9-7-15, and sections 6 and 7 of the Commission's Rules of Procedure. A public hearing is now open and before the Historic Preservation Commission on the following application for a certificate of appropriateness. This is COA application number 2021-0012, the application of Rob O'Connor regarding the property at 407 Jarvis Street. The proposed project at issue is a request for a COA for handrails on the porch. Please note that this application for certificate of appropriateness is commonly referred to as a major work COA. And let's see, we have swearing in of all the witnesses on the list here. Do we have to actually do that, Mr. Attorney?
Yes, sir. And actually, under the new statute 160D-406, you as the chair have the authority to swear in the witnesses. And so what you would do is just say, do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God? That's typically what is done, even though the individuals have already signed a notarized oath form. It's kind of reiterated at the hearing.
Okay, that is not on my script.
Okay, I'll be glad to help you out with that.
Okay,
And so it looks like we have two speakers on for the first item. That would be Planning and Development Services Director Thomas Barnett, who's the city staff and city representative. And I think it's probably best to go ahead and swear him in for both matters for tonight, all in one fell swoop. And then the second would be Mr. Rob O'Connor, I believe, is the second witness. Is that correct? Are there any other speakers for the first item?
Ricky
Mr.
Hill.
Attorney.
Yes.
For items 1 and 2, I'll be presenting for city.
Okay,
And-
I'm sorry.
And Mr. Barnett will be presenting for the city on item number 3.
Okay, so city staff for item, all of the city staff that will be for items 1 and 2. Item 3 is not an evidentiary matter, but items 1 and 2 are. So are there, who are the city staff? Again, it was you and on items 1 and 2, just you,
That's
Mr.
myself.
Parker?
Yes, sir.
Okay, so Mr. Chair, you would just say, do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
and Mr. Parker, do you solemnly swear that the information that you'll present on this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
And then the other individual who is speaking on tonight's, well, we'll cross that when we get to their testimony. So the swearing in for, and this will apply for both items 1 and 2 as far as the city swearing in of the city's witness.
Okay, and I believe we have Mr. O'Connor with us tonight to discuss his COA. Do we need to swear him in as well?
Yes, sir, you will. But you can go ahead, you can do that now, or you can do that but right before he presents his side, his case.
Well, let's go ahead and get it out of the way, then I don't have to trip over it.
Okay, not a problem. And let me see, let me find, okay, Mr. O'Connor. So the same will go for you, and Mr. Jordan, as the chair, will repeat. Do you solemnly swear or affirm the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God? Mr. Chairman, if you would repeat that.
All right, Mr. O'Connor, do you solemnly swear or affirm that the information you will give the board tonight in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I have 2 other preliminary matters. This is both for Mr. O'Connor and for Mr. Parker. Mr. Parker and Mr. O'Connor, did both of you receive the remote meeting notice for tonight's meeting?
Yes, sir.
And did both of you also consent to this meeting being held by remote means?
Yes, sir.
Yes.
Okay, Mr. Chairman, I would like to make in accordance with the remote meeting and standing laws under the state of North Carolina, is there a motion that the commission find and conclude that both Mr. Parker and Mr. O'Connor have standing to participate in this remote quasi-judicial proceeding because both Mr. Parker represents the city and Mr. O'Connor is the applicant, and that both received notice of the quasi-judicial meeting and that both consent to the meeting being held in a remote platform? And if so, if that is the motion, is there a motion? If so, someone could say so moved.
So moved.
All right,
Lauren
we have a
Couch.
motion from Mr. Casper, do we have a second?
So, second, Andrew Moorhead.
We have a motion by Mr. Casper, seconded by Mr. Moorhead. Can we have a roll call vote, please?
Yes, sir. Jeremy Jordan,
Aye.
Candace Pierce,
Candace Pierce, aye.
Andrew Moorhead,
Aye.
Israel Mueller,
Aye.
Myron Casper,
Aye.
Scott Wells,
Aye.
Justin Edwards,
Aye.
Carrie Carlin,
Aye.
Robert Wright. You're muted, Mr. Wright.
Aye.
Thank you.
Thank you.
Mr. Chair, the motion was passed unanimously.
And Mr. Chairman and members of the commission, I do apologize for that formality. And so I'll turn it back over to you, Mr. Chairman, for the presentation of the continuation of the case.
All right, thank you, Mr. Phillips. And now the commission will hear from city staff's preliminary statement describing the application. Mr. Parker?
Okay, let me share my screen with you all. And let me say also that I really appreciate you being here, and it's a pleasure to be here as well. So here we go. This is a property that's over on Jarvis Street. It's 407 South Jarvis Street. It's a contributing structure. Our applicant is Robert O'Connor, and he's here this evening. This is an after-the-fact COA. He had added a handrail to the front porch. Our notices and signs went out on the 13th. This is the location of the property, and you can see it's between 5th Street and Jarvis Street. This is a description of the house. It was built in 1925 as a 2-story duplex. The frame gabled roof has features associated with the Craftsman bungalow style. The knee braces and single and paired 4/1 sash windows illustrate the elements of this style. And a large gable roof porch covers the full width of the 3-bay facade. This is a picture of the house at 407 South Jarvis Street. You can see the sign that was placed out there. The applicant installed a handrail to bring the front porch up to current city code for the safety of his tenants and their guests. Stairways having 4 or more risers above the floor or finished ground level shall be equipped with handrails located not less than 30 inches, no more than 38 inches above the leading edge of a tread. An exception from this standard is that handrails that form part of a guardrail may be 42 inches high. This is a copy of the Design Review Committee notes. This here is a picture. You can see the handrails right here on the porch. From our design guidelines, Chapter 2, porches, entrances, and balconies. Historic porches, entrances, and balconies must be retained and preserved. All architectural features that are character defining elements of porches, entrances, and balconies, including piers, columns, pilasters, balustrades, rails, steps, brackets, soffits, and trim must be retained and preserved. The introduction of reversible features to assist people with disabilities must not diminish or damage the original design or materials of the porch or entrance. Staff findings are that the handrails are reversible features which do not damage or diminish the original design or of the porch or entrance. There are no added elements or details to create a false historic appearance. The Design Review Committee did meet, and the DRC met with the applicant, Rob O'Connor, who had added handrails and porch rails to the property after a visitor had fallen off the porch. Neither of the features are original to the property. The applicant volunteered to remove the porch rails. The DRC unanimously approved the handrails as installed. And at this time, I will answer any questions the commission will have of me.
Any questions before we hear from the applicant?
I guess I have a question. That the house description that was just read states that it's a 2-family home. Is that correct?
That's correct. And that came from the architectural survey.
Right. And there are 2 front doors on the front porch. Is that correct?
That's correct.
Well, tell me, why is there a staircase leading to the 2nd floor on the left-hand side of the house?
I can't answer that. I've not been on the property to investigate that. I'm not sure what is upstairs. And I think our applicant can answer that.
Well, I got another question. Has
Yes, sir.
anybody counted the number of electric meters on the house?
No, sir, I have not.
Anybody else in the commission?
That was not part of the COA, so I doubt if anybody's done it.
I know.
Okay.
Would you guys like to hear from the applicant now? Maybe we can ask him some of these questions.
Yes.
All right, if you'd state your name for the record and tell us about the application.
Robert O'Connor, the address of the application.
Yes, just for the
Oh,
record.
it's 407 A, B, and C South Jarvis Street, Greenville.
Okay, if you just go ahead and tell us about the application.
Yeah, on the front
Well,
porch.
You haven't answered my question yet.
Yes, sir.
If the house is listed as a two-family home, why is it now a three-family home?
Well, the family is listed, I'm not sure what Tony was referring to, but as far as the city's listing and the zoning's listing is listed as a multi-family. And there are 3 power meters. There's one for A, one for B, and one for C. A and B are on the front, and C is on the top, and that's what the stairwell goes to the third apartment up top. It's been an A, B, and C as long as I remember it. And then back to the application, the front porch where someone was walking down, they had slipped, and I had put the rails up there just for safety and liability, because if it happened again and I was informed of it and I didn't do something about it and I was sued, then it'd be my fault. At least now I took action to try and mitigate that risk. And that's why I installed the handrails.
This is Candace Pierce. I'd like to address Myron's question.
Okay,
That house was changed from what the survey said, which was it was originally a duplex. During the period of time that the city allowed a period where there could be more than 3 people unrelated, it was during the 4 unrelated event, which lasted for a while, and then they went back to 3 unrelated. No one can actually keep up with the number of people in there that aren't related. There's several people in my house that aren't related. However, we're all related. It's the names that are different. So it has been and is an accurate use. The original survey is mistaken. Mr. O'Connor is correct and has the right to have that house have those 3 apartments in it.
Thank you. Just looking for an explanation,
Well, of course, I have one, Myron.
and I accepted it.
sorry. Does anybody have any questions for Mr. O'Connor about the project?
I do actually, although more in the terms of a follow-up, because I think that the reasoning of safety is an important one. I'm just curious as to whether there was consideration to putting the rails between the columns. I mean, it's an architectural issue to some extent, but on the flip side, I'm not sure what the regulations are about having the handrails across between the columns on the left and the right of the staircase, because it seems to me that people are just as likely to fall off there thinking they're going down the stairs as they are to the left or the right. So, I think that's a question maybe for the design review committee moving forward. But I'm just curious if there's a rationale to not basically putting the rails all the way around. I mean,
I can answer a little bit of that. If anybody else that was at design review would like to step in, please do. When we were at the design review committee meeting, we discussed the rails that had been put up on the porch. And we also talked about the regulations that require rails if the porch is above a certain height, which I believe this one is not. But the compromise was to leave the rails on the steps so that people would have something to hold on to as they went up and down.
That's accurate. And it's 30 inches. If it's higher than 30 inches, you have to have porch rails. Otherwise, you do not by code.
okay. I see the reasoning there. I'm just sort of pointing out that if I was getting a major work COA I probably would have done the railings all the way around. My own home has, railings to keep me from falling off my own porch, which is also under 30 inches. So just, again, not
Actually,
really an issue.
that was my original application, and the railings did go from the front and the side. But then I was told at the review committee that since it wasn't high enough, they had to come down. So I had those removed. But they were originally installed and were there, but I was told they were removed. And now that I was told to have them removed as opposed to me removing them, that shifts liability from me. So I'm just doing what I'm told.
I appreciate it. I follow the reasoning that it's not over 30 inches. It just,
It's always, this is Candace Pierce, it's always going to be a judgment call. And the way that the design review committee has always worked best is to know what someone is planning to do in time to use Article 6, which is create a variance. It almost always works better that way than when someone puts something back, puts something that is immediately against one of the guidelines that Tony just picked out. So if Mr. O'Connor wanted to put the railings back and approached it from the requesting and making a variance, that is possible. Not that he really wants to or needs to, but that on other houses, depending on the situation that's changed since we originally created this district, the design review committee tries as hard as we can to make what the homeowner wants to do get into the design guidelines if it's possible. So that's how that rationale ended up happening.
Okay, do we have any further questions for the applicant? If not, Madam Clerk, do we have anyone sign up to speak in favor or against this application?
No, sir, we don't.
Okay, let's see. So Mr. Attorney, help me. I know what I need to do. I just don't know exactly how to follow the rules about it. We're ready for discussion about if we have a motion to approve or not, I believe.
Yeah, so if there's no other questions and no other presenters, you would just close the public hearing and proceed to any commission discussion, and then proceed accordingly with your approval of findings of fact and your application for COA with any conditions, if any conditions need to be. But before that, you probably need to hear the recommendation from the city staff on it, which I think maybe he's already done.
I think that was in the presentation, was it not,
Yeah.
Mr. Parker?
Yes, it was.
So
Okay.
you just close the public hearing and then go to your deliberation.
All right, so I'll close the public hearing at this time. Is there any discussion? If not, is there a motion to accept the findings of fact?
So moved.
All right, we have a motion by Mr. Collins. Is there a second?
Second.
We have a motion by Mr. Collins, seconded by Ms. Wells to approve the findings of fact. Can we have a roll call vote, please?
Jeremy Jordan,
Aye.
Candace Pierce,
Candace Pierce, aye.
Andrew Moorhead,
aye.
Israel Mueller,
Aye.
Myron Casper,
Aye.
Scott Wells. Aye. Justin Edwards,
Aye.
Carrie Carlin,
Aye.
and Robert Wright.
Aye.
Mr. Chair, the motion was approved unanimously.
Okay, thank you. Now that we've approved the findings of fact, is there a motion to approve the COA?
And again, my apologies with that, to approve the COA and that the proposal, and this is statutory, is congruous with the special character of the historic district, and that the applicant's application should be approved. That would be the motion.
We used to say is congruent with the design guidelines. Does that work?
The statute says it's with the historic district, and you could add to that it's congruous with the historic district and the design guidelines. That would be appropriate if you would like to add that.
Okay, would anyone like to try to make such a motion?
This is Candace Pierce. Whoever else was doing it.
Oh, Robert Wright.
Are you going with so moved, Mr. Wright?
Yes, I was so moved, yeah.
Okay, do we have a second?
Still learning.
Do we have a second?
I'll second that.
All right, we have a motion by Mr. Wright, seconded by Mr. Moorhead. Can we have a roll call vote, please?
Yes, sir. Jeremy Jordan,
Aye.
Candace Pierce,
Aye.
Andrew Moorhead,
Aye.
Israel Mueller,
Aye.
Myron Casper,
Aye.
Scott Wells. Aye. Justin Edwards. You're muted.
Sorry, aye.
Carrie Carlin,
Aye.
Robert Wright.
Aye.
Mr. Chair, the motion was approved unanimously.
Okay, thank you, Mr. O'Connor. The COA is approved. We are welcome to stay with us, but if you want to leave, we understand that too.
All right. Thank you all. Have a great night.
Thank you,
Thank
Rob.
you.
Bye-bye.
Bye-bye.
Okay, let me go back to the start here to our legalese I have to read through here. We'll start over again for our next COA.
Mr. Chair, for purposes of expediency, that portion should be okay, other than if you're just introducing the application, et cetera. That part you would need to read. And then we've already sworn in the city staff for that, and already have found that the city has standing and notice and consent. So that portion would really only apply the oath, and that one question would apply to the speaker for the applicant in this matter.
Okay, do I need to read the statute numbers out again, or just start with the introduction of the application?
You're fine with the introduction.
Okay. This is COA application number 2021-0018, the application of Ricky Hill and East Carolina University regarding the property at 601 and 605 East 5th Street. This is a project for driveway and various landscaping. And I believe we need to swear in Mr. Hill at this time.
That's correct, Mr. Chairman. And Mr. Hill, this would be directed to you. And then Mr. Jordan, let me go back over the for Mr. Hill. Do you solemnly swear or affirm the evidence you shall give the board in this action is actually be the commission? In this action shall be the truth, the whole truth, and nothing but the truth, so help you God. So, Mr. Jordan, if you would swear in the witness.
All right, Mr. Hill, do you solemnly swear or affirm that the information that you give the commission on this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right.
And Mr. Hill, you received notice of this meeting by way of a remote meeting platform, correct?
Yes.
And you consent to this matter being held on the remote meeting platform?
Yes.
And is there a motion that Mr. Hill, who is the applicant, has standing to participate in this remote quasi-judicial proceeding, that he has properly received notice of the remote proceeding, and that he consents to the remote proceeding?
So moved.
Do you have a second?
Second.
All right, we have a motion and a second. Can we have a roll call vote, please?
Yes, sir. Jeremy Jordan,
Aye.
Candace Pierce,
Candace Pierce, aye.
Andrew Moorhead,
Aye.
Israel Mueller,
Aye.
Myron Casper,
Aye.
Scott Wells,
Aye.
Justin Edwards,
Aye.
Carrie Carlin,
Aye.
Robert Wright.
Aye.
Mr. Chair, the motion was approved unanimously.
Thank you. Okay, I'll note that city staff has already been sworn, and we'll go ahead and hear the city staff preliminary report on the application.
Okay, thank you guys again. Bear with me for a second. Let me get that going here. Okay. So here we go. We are now looking at the Proctor Young House and the Dale House, two houses that are very familiar to us. It's at 601 and 605 East 5th Street. The applicant is Ricky Hill on behalf of East Carolina University. Their project is to create a new driveway and upgrade the landscaping. Notices and signs went out on the 13th. You can see on the location map here that the properties are between South Summit Street and South Jarvis, located facing 5th Street, right across from campus. Erected in 1917, the Proctor Young House at 601 East Fifth Street is a substantial two-story frame house built in the colonial revival style. The house and grounds, as you know, have undergone major renovations over the past several years. The Dale House, formerly the Chancellor's House at 605 East Fifth Street, was built in 1921. The home represents the most academically fashioned house in the district. The 5-bay blonde brick house is a striking example of domestic Renaissance revival architecture. That's a picture of the sign I had posted out there in between the two properties. On the left is Proctor Young, on the right is the Dale House. This is a copy of the Design Review Committee notes. The applicant wishes to create a landscape utilizing native species while removing an invasive and non-native species of bamboo and the damaged planter. There will also be renovations to the driveway and the back entrance to conform to the Americans with Disabilities Act, otherwise known as the ADA, as well as merge the two independent driveways together. This is a rendering that Ricky Hill sent over to us. It's a aerial view of the Proctor Young house right there. You can see the new drive with the walkways and the plantings. These are pictures currently of what the backyard of the Proctor Young house looks like. And the planter that will be removed, you can see that invasive bamboo is right there and it is pushing the wall down. This is a view from Summit Street. It's a rendering looking towards the Dale House at the back of the Proctor Young house. These are some items that came out of the design review. Design guidelines. Chapter 2, Life Safety and Accessibility. Health and Safety Code and accessibility requirements must be met in ways that do not diminish the historic character features, materials, and details of the building. Number 5, when introducing reversible features to assist people with disabilities, diminishment of the original design or of the porch or the entrance and damage of historic materials or features must be avoided to every extent possible. From Chapter 4, Driveways and Off-Street Parking, use driveways to access side and rear parking areas and garages. New parking areas must be located as unobtrusively as possible in an area screened from public view. For new parking areas, paving materials compatible with traditional paving materials for driveways in the district must be used. Permeability should be maximized. All new parking areas must be screened from adjoining properties with fencing or shrubbery. Same chapter, Chapter 4, with landscaping. If a landscape feature is completely missing, it should be replaced with a new feature compatible with the character. New landscaping features should be consistent with similar elements in the historic district. The location of new landscaping features should be consistent with the location of similar elements in the district. And the existing large trees and other significant landscape elements must be incorporated into plans for additions and new construction. Staff findings, the landscaping will return the native fauna to the property and it's consistent with other properties in the College View Historic District. The larger existing tree on South Summit Street will remain. The added parking and ADA enhancements will be located in the rear of the property. It will be screened by new native planting to screen the area. The Design Review Committee did meet. The DRC met with Ricky Hill and John Gill, representatives of ECU. ECU proposes to add a new concrete driveway and 3 parking spaces at the back of the house, connect the new driveway with an existing driveway at the Dale House. They intend to improve access to the back entrance and an ADA ramp with hardscapes built out of concrete and pavers. They're going to improve landscaping by removing damaged planter wall and bamboo and incorporating native plants around the Proctor Young house in the area of the removed planter wall. The DRC unanimously recommended approval. And for staff recommendations, we believe that we need to allow the improvements to landscaping, parking, and ADA improvements to proceed as stated on the COA application and as approved unanimously by the Design Review Committee. And that is my presentation, and I am here to answer any questions for you.
All right, any questions of the staff before we move on to the applicant?
Yes, I have one, just curious. There is strip parking there going to the house, and you're proposing a solid driveway. And is that consistent with the permeability of the ground? And is that consistent with the with our, regulations to change that. And is that a part of the regular historic construction, I guess?
The
I'll say that-
permeability, I'm not positive about what we have there. We know that it looks, when it was presented to us, we felt like it was, hello? We felt like it was within the standards of the guidelines. And so we feel confident that this proposal is something that is worthy, and the DRC had unanimously approved it, and therefore we recommend approval as well.
And Mr. Wright, I would just add to that part of the purpose of the driveway, there's 3 parking spaces, is for ADA accessibility to the ramp.
Right.
And they need a paved surface for the wheelchairs, or if needed, to be able to get to that ramp and not get stuck in, grass and whatever else.
Okay, that answers the question. Thank you.
Okay, thank you, sir.
Other questions for city staff before we go to the applicant?
Well, I guess save it for the applicant.
Okay. All right, at this time, if we could have the applicant to state your name for the record and tell us your information about the project.
Okay. My name is Ricky Hill, Director for Facility Services at East Carolina University. I want to thank y'all for hearing this request today. This is the final stage we hope for phase for work for the Proctor Young House. We have done an extensive exterior renovation as well as a total interior renovation. And this kind of brings this project to closure for us. So the project is as stated, was to provide the driveway and entrances that basically is for our ADA purposes. We are limiting the minimum amount of parking for this facility. The people that will be in this building will actually park on main campus and walk over to the location, to the site. The planter wall has been in disrepair for some time, and that is something that we would like to do and connect it for to help with access to the Dell House and not having to come out and back out and have a safety issue with the Dell House driveway coming straight onto 5th Street.
I guess I can ask my question now. In your chapter 4 section, part number 5, new parking areas must be located, etc. I presume these statements are consistent with the new parking regulations that are now part of the city code.
Is that a question for me or for Tony?
I'm not sure who I'm talking to. I thought I was talking to Ricky Hill.
Okay, can you repeat your question and make sure I understand that and understand your question?
My question refers to chapter 4 that you have listed here in item number 5, new parking areas must be located as unobtrusively, etc. That statement, I believe, is taken from the new city ordinance for parking areas in this zone. Is that right?
That actually, Myron, that was taken from our design guidelines.
Okay. Well, then my question is in the wording. It hardly seems to me that this parking space is unobtrusive. And if you go back down to your landscaping, that same ordinance requires that the new landscaping should be consistent with similar elements in the historic district. And then that statement goes on to say that it includes a good deal of planting. We don't see that at all.
What is it that you don't see, Myron? This is Candace Pierce.
There's no planting that that encompasses this parking area.
Can you put
The-
that up, Tony?
Quite specific in describing shrubs and trees that must be located. I'm also not entirely sure if that ordinance doesn't also include some statement about the size of the parking area.
Okay.
The verbiage came right from the design guidelines. And if you look at the renderings that were sent over there's quite a bit of new plantings in this area right in here. And right in here that will help screen this ADA required parking area.
Now, what's screening the parking lot, the driveway and the parking area? I guess really the question is the guidelines or the city ordinance that takes priority here?
It's always health and safety. No matter what the ordinances are, handicapped people have the same rights everyone else
No,
does.
I'm talking about handicap. I'm talking about it's a parking area. And the city describes parking areas in great detail. It doesn't seem to me that any of that great detail is included in this parking area.
Where is it not included? Are you talking about the part on the left that's big and gray to access the turning arounds of vans, or where? Behind it?
Well,
Do you think we need more plants on the left?
there's no coverage on the left side at all. I don't know whether it's appropriate to consider the Dale House and the Young House as contiguous, so there'd need to be plantings that includes shrubs and trees, and there's nothing there that looks like shrubs and trees to me. And as I say, I'm not familiar with the exact size of the parking area, but this is pretty darn large.
Well, there is a screen, landscape screen, as you can see in the kind of perspective view that's shown there. I can see 6 trees there, and we have a heavily landscaped area between the 2 properties. Now,
Yeah, I don't think those are consistent with the city ordinance.
Are there?
So I guess the question asked is what takes priority, the city ordinance or our guidelines?
I think that comes back a little bit to Mr. Wright's question about the permeability. I think that's the part that falls into the city ordinance. I think both of them require screening of features like this in the backyard. And to me, I'm looking at the site plan on the right and the previous slide that shows what looks like a couple of existing trees. And I think they're not maybe shown in this perspective. Like there's trees on either side of it. And I just think we're not seeing what's to the left side of that photo, and maybe Ricky can tell us what's sort of back there. And of course, if he wants to come over to my house and tear out the bamboo I've got, he's welcome to do so, because that is a disaster. But anyway.
Not original to the property either.
No.
All the landscaping you see on the plan is new, except for those 2 trees that are right on Summit. So those are the existing trees. Now, of the view you're looking at now, to the left of that is actually all grass area now currently. If you remember, that is actually where there were 3 houses that were demolished, and that is a green grass area at that location. Now, we certainly have no issue if we need to install some landscaping along that left side of the driveway. That is not an issue for us. We would be glad to put anything there that would be appropriate to help screen the parking lot.
Ricky, that also might keep the people playing ball in the grassy area from getting all over your parking place, which might help too.
Mm-hmm. We have no issue with adding additional landscaping there.
And Ricky, it's been a long time since I talked to Vice Chancellor Nieswander about the plans, but I thought there was actually a plan to put either a fence or some additional screening along that side long term anyway, right? Back where the houses were demolished. So that was.
Yes. Well, we haven't been given any real direction as to what the use of that is. So until we kind of have, that's been further developed by the university administration or determined by university administration, we will respond with that as what would be appropriate once that kind of use is determined.
And Mr. Hill, aren't you working with some COA applications regarding that property in the future?
You talking about the lots where the houses were demolished?
No, I'm talking about anything you're planning to do with those two pieces of property. You're planning to go and present a COA to us. You were talking about preparing them at a
Yes,
meeting
yes.
with
Yes,
Tony.
I actually have already have some minor requests in to Tony, and then we've got a couple of other major requests that we're working on to submit, hopefully for the next meeting.
Regardless of the minor issues that we may be having, in my opinion, the state of North Carolina and East Carolina University is doing a very good job communicating with us and producing a product that fits in with the character of the neighborhood. And I personally am grateful.
All right, do we have any further questions for the applicant? Looks like there's none. Madam Clerk, is there anyone signed up to speak in favor or against the COA?
No, sir.
Okay, at this point, I'll go ahead and close the public hearing then, and we can go into our discussion. So anyone have any thoughts? This is a point where we could discuss any special conditions that were to be added, or if the majority does not find any, we could have a motion to approve the findings of fact and go from there.
I guess I'd like to see the stipulation be made that that parking area be consistent with the city ordinance, particularly respect to the requirement for size of space and the plantings that would be required be added in.
Excuse me, who knows which city ordinance we're talking about? I mean, by number. Mr. Barnett, Tom, I mean, which ordinance are we talking about? It's not our guidelines, right?
No, it's not
city.
guidelines, it's a city ordinance.
Okay, what is the city ordinance, Mr. Barnett, that talks about trees and stuff?
That talks about which, I'm sorry?
Trees and plantings and stuff.
That would be under the zoning ordinance, requirements for improvements to the site plan. So one of my, if I may, one of my questions is, because this is essentially, is this state-owned property, Mr. Hill, I think it is. The city is limited in how much input we have because they go through the state. They don't come necessarily through our local review process. Like under building, for example, in code, and then zoning, they got to comply with the underlying use, but they get to do kind of what they want to do. So I'm not sure if Shantae, I think Shantae may have just tuned in. Shantae would be our expert on what we can and can't do zoning wise, but the state is sort of above our ability. And it's not, Shantae has texted me, it's not reviewed by the city and it's exempt. So we don't have an oar in the water in this one.
So would it be correct to summarize by saying that this entire process is a courtesy of the university?
In terms of it, not in terms of historic preservation, but in terms of zoning compliance. You guys do have the right to ask them to do certain things under the historic preservation
Okay, that's an important point.
Right.
And the East Carolina University for years did not bother to discuss with anyone. None of these people that are, this isn't you, Ricky, did not bother to discuss with anyone when whole buildings lay down. And we are pleased that as a neighborhood, it is helpful to the neighborhood and the character of the neighborhood that East Carolina comes to us and asks us to fill in their guidelines and plant some more trees or whatever. Not that everything my alma mater has done that's made me thrilled with their historic preservation, but this particular property, considering the possibilities that could have happened, is really, they've gone beyond what is even recommended to talk to us about it and accommodate our plantings and our whatever we're going to do.
And
It's a courtesy.
I would add to what Candy is saying that the fact that the Proctor Young House is even still standing is a testament to ECU working with the Historic Preservation Commission. It was sort of a trade-off to save that house to preserve the Fifth Street streetscape when all those other houses were torn down.
The other thing that I noticed too, looking at the plan, is that the guidelines comment on screening from adjacent property, and the way the plans are laid out, the adjacent property is those vacant lots that ECU owns. So I'm not really sure that that becomes even something that we can have any control over or discuss.
Agree with that. And I also believe that if Mr. Hill comes back and says he wants to put a fence there, we will say, if you'll put it in the way that he knows we want it, we'll probably say yes. And if he wants bushes behind the fence, we probably will say yes too, because we're trying to have a town and gown event here.
Well,
It
Hill,
improves the
commission,
ability.
and I would be delighted to hear him say that he would like to plant some of the same trees they planted along Jarvis Street, which are very lovely and will be quite beautiful shade trees. So if you'd like to put 3 or 4 there along that driveway, I hope that we will not complain about that either.
Yeah, so like I said, I'll consult with our landscape architect for the university, and we'll certainly do the best that we can to be a good partner with the city. Okay.
Thank you.
Okay, so we're doing a lot of feel-good talking right now, but we do have to address the COA.
Better than the bargain.
I like it when we do feel-good talking because we all need a little of it from time to time. But if we're done, we're still waiting for either discussion on requirements, additional requirements, or a motion to approve the findings of fact.
I'd like to make a motion to approve the findings of fact.
Candace Pierce, second.
Mr. Edwards, and a second by Ms. Pierce to approve the findings of fact. Can we have a roll call vote, please?
Yes, sir. Jeremy Jordan,
Aye.
Candace Pierce,
Candace Pierce, aye.
Andrew Moorhead,
Aye.
Israel Mueller,
Aye.
Myron Casper,
Hi.
Scott Wells. Aye. Justin Edwards,
Aye.
Carrie Carlin,
Aye.
Robert Wright.
Aye.
Mr. Chair, the motion was approved unanimously.
Okay, thank you. And now that we've approved the findings of fact, do we have a motion to approve the COA?
And that the COA
It's
is
congruent with
congruous
the
with the special character of the historic district and the guidelines.
Mr. Phillips, I can make motions, can I not?
Yes, you can.
Okay, in that case, so moved. We have a second.
Candace Pierce, second.
Okay, we have a motion by me, seconded by Ms. Pierce to approve the COA. Can we have a roll call vote, please?
Yes, sir. Jeremy Jordan,
Aye.
Candace Pierce,
Candace Pierce, aye.
Andrew Moorhead,
Let me unmute, sorry. Aye.
Israel Mueller,
Aye.
Myron Casper,
Aye.
Scott Wells. Aye. Justin Edwards.
Muted.
You're muted.
Sorry, I wasn't when I said aye, but aye.
Carrie Carlin,
Aye.
Robert Wright.
Aye.
Mr. Chair, the motion was approved unanimously.
Okay, thank you, Mr. Hill. The application is approved. We thank you for joining us tonight. You're welcome to stay, or if not, we understand.
Thank you very much for your time.
All right, that takes us down to item number 3 under new business, which is anti-demolition by neglect ordinance.
We have one other item in there. Jeremy, we do have a minor work I'd like to run by you.
Oh, I have a discrepancy between my 2 sets of documents here. Okay, we'll go into minor works as I don't.
Sorry about that. Okay. This minor work is one that you all have seen before. It's at 215 South Library Street. The owner is Robert O'Connor. He is replacing a dilapidated fence. He's repairing the dilapidated fence. There's been some burning going on there in kind and in style. And he's painting the front door white. And this is a picture of the front of the house and the fence is in the back. This is a fence that's Shante had met Mr. O'Connor there and discussed the fence. And there's apparently a bonfire in the backyard that hit part of the fence, and he's just repairing the burn parts. If you have any questions about this, I'd be glad to answer them.
It looks like the house the door is already painted white. Looks good.
It is. It is. Yep.
And
Any of the code enforcement people go and cite the owner of the house for having a bonfire in the backyard? I'm pretty sure that's illegal.
He has spoken with his students who live there about several issues, and he and Shante have talked about that as well. So he's informed.
Some of us don't want our houses burned down by students having bonfires in the neighborhood.
Right.
How about that swing at the front yard?
It's gone. Myron, when Shante talked to Robert, she insisted that it come down. And so he took it right down right then and there. It's gone. Front yard looks much better than it has in a long time.
And the parking in the front yard, is that gone too?
That I don't recollect parking in that front yard, but there's another property, the Dancy property, that I haven't brought to you tonight, but I will next month. But we worked with him and we got the parking out of the front yard on 3rd Street. That big brown house you'd been talking about. He raked all that gravel up. The grass is coming back. There's no more railroad ties out there. They're not parking in the front of that property anymore.
It looks beautiful, except for when they park the truck and the cars occasionally. But you know, that now that you bring that subject up, that's one of my favorite peeves about this neighborhood. I have photographs going back 4 years of cars parked in that front yard, and about 3 weeks ago, they all disappeared. They disappeared for a whole week before they reappeared. And today, in the last few days, they're all gone. So I applaud your efforts, and I hope they continue.
It's a work in progress, as you know, and but right now we're making progress, and that's a good thing.
Okay, and 1002 East 3rd Street has 2 cars parked in front of their yard almost all the time. Anytime after 4:30, and on all weekends, there are cars parked there. So with 803 having been finally reined in, I hope you put your same efforts to work on 1002 East 3rd Street.
I will be on it tomorrow morning. I'll make sure I make a phone call for you.
Well, make it for the city, make it for the neighborhood.
Yes, I mean for all of us, for our community.
Right.
I wanted to add just real quick, we noticed that front door on that property that was painted white. Design Review Committee did discuss purple doors with Mr. O'Connor when we met with him about the porch rails. And he has agreed to, over time, as these properties turn over and things have to be repainted, to get rid of the purple doors. So we should be seeing that phase out over time.
Fully.
Okay, and now we'll move on to item number 3 on a new business, which is the anti-demolition by neglect ordinance.
So if I may, I'm Tom Barnett. I'm Director of Planning Development Services, and I'm here to just kind of discuss with you briefly. First of all, I'd like to start out by saying that when HPC decided to take this back up, I know our city attorney, Donald, got to work on looking at there was an ordinance written in the past, And then he also actually contacted a number of cities that have some ordinances sort of to take a look at how they do it. What I wanted to discuss with you tonight was a couple of things. I'm asking for you to proceed in the following manner, essentially sending over the resolution. What I'm hoping to get out of that is a direction from City Council, should they so choose, to direct staff to do some more homework in terms of trying to figure out the best process for being able to do something like this, and also begin to figure out what this means in terms of staffing issues. And I'm telling you what you already know, but bear with me if you will, in case we have some of the public watching. As a quasi judicial board, the actions of the Historic Preservation Commission are very important, and also come with a lot of strength, if you will. So when we are in very much a property rights state, so when we start getting in the situation of telling people to fix up their place and also how to fix it up, we can get ourselves into a situation where people are unhappy. I know you've seen this before. It's not news. But under demolition by neglect ordinance, we're essentially saying to them, here's what you're going to do, here's when you have to do it, and here's how you're going to do it. And then, oh, by the way, if you don't, here's the penalties if you don't. And then, we essentially can issue fines, penalties, and ultimately, the risk is a person can lose their property should those penalties add up, and should the city determine to act in that manner. Obviously, the intent is not that, but the intent is to get people to fix up their place, which is, I think, a very worthy thing. These ordinances are very strong, and they require a lot of intestinal fortitude on the part of all our boards to back them, because when we start going after anybody in particular because of the nature or the condition of their structure, we will be hearing about it. The manager's office will hear about it, and certainly council will hear about it. So I want to propose that that staff have an opportunity to come up, working with the city attorney's office, to come up with a strong ordinance that lays out a process that will stand the test, the legal test, and will stand up, lay out who the appeals are, how we go about doing it. And then again, as I said, I believe there'd be the need for probably some staffing increases. These are very, they can be onerous in terms of staff time needed. I'm guessing, given the workload right now of our city attorney's office, they are very busy right now, and they have a ton of stuff, and I don't think that they'd be able to take this on and do it justice as we started moving down the road if this gets adopted. So I'm guessing you're looking at anywhere from another half attorney to a full-time attorney to help with some of their overload, but to take this on, as well as I'm guessing probably an additional planner to take on the additional burden. So I just wanted to sort of put that out for the commission to consider tonight. When they're thinking about this, these can be very powerful and effective ordinances, but again, they take a very strong forward-looking backbone, if you will, and the city needs to make sure we get it right in terms of the quality and the legalese on how we do this. So that's what I wanted to say in terms of this resolution. Donald had already done some work, I know, on beginning to draft and to make change. I think there was a former city ordinance, I believe back in 2013, that tried to get this done back then. It didn't grow the right legs. I'm not sure why, but it just didn't. And he's taken that on and started looking at making some of the changes. But he's also indicated, after I reached out to him and we began talking about this, that we need to make sure we get the process right, we get this thing nailed down correctly, so that we do it in the most appropriate legal manner to be the most effective for the desires of HPC and the community to get people to fix their places up.
I have a couple of questions for Mr. Barnett and or Mr. Phillips, but I think, Mr. Wright, were you stretching or did you want to say something?
Well, I just had a question. Is this limited to historic properties? I think the way I read it.
Yeah, as conceived, it is, sir. It's just in the historic district or local designation properties, is my understanding.
Would that take a half full-time or a full-time attorney to do that?
It
We
could,
need
depending on how many cases are brought, because there'll have to be hearings held. We'll have to have finding the fact. We'll have to go investigate. There's going to be a rigorous, almost court-like process to get through this. Is my opinion, and what we found talking to some other communities that have this in place already. It's not easy and it's not quick to do it right, because the legislature passed some recent law that if we kind of mess this up, the city can be liable for court costs if we lose a case that's brought against us.
Okay.
Okay.
I don't know, Donald, if you want to jump in.
So I'm sorry.
I
Go
want to
ahead.
jump in.
Well,
This is Candace
okay.
Pierce.
Well, I was going to ask a question, and then I'll come to you.
Okay.
First of all, I am in favor of pursuing something like this and see what we can do with it. But I have a question. If we were to forward this to City Council, and if they were to think it was a worthy cause, and and if we get something like this put into place, does it have to? And this might be a question that can't be answered now, but is it a cut and dry? Yes, this is wrong. Yes, you fix this, or is it a case by case? Whereas a lot of these older properties, people buy them and live in them, that work on them over time, myself included. So if you have a piece of rotten fascia and you also have a leaking roof, obviously the leaking roof is more important. So if you see where I'm going with this.
My understanding is the way it works is we would have to hold a hearing. Somebody would be appointed the official to hold a hearing. That could be me or somebody I designated, perhaps a planner that we would get that would help do this. But whoever does it is going to have to sort of preside over a hearing scenario where you take evidence from, those who are bringing the case, which will be a combination of staff, and I assume based on recommendations also from the commission. And then they would be based on some of the historic requirements and good practices around the country. And then, we'd hear both sides, the response from the owner. And then we'd sort of have, there's always going to be some, and I don't like it. I mean, I like things cut and dried because it's much easier. It's a yes or no. But in these kinds of proceedings, it's never that cut and dry. So you're going to take evidence, you're going to hear, and then ultimately you're going to make a decision. So there would be time to allow somebody to come forward and say, I got these 3 issues. I can't take them all simultaneously, but with your permission, I can do the roof first in your scenario, and then I can get to work on the fascia maybe in 30 or 60 days or whatever it is. And if, as we try to set the parameters for how we operate, that would either be acceptable and we'd allow some leniency, because it's always good to start giving people an opportunity if they show a willingness to comply. But then if they don't, and then if they don't and days pass, then we go back out there and bring them back in, and we perhaps, assess more penalties. But yeah, I mean, there would be ways to deal with that.
I have seen it work in Washington, North Carolina, as in Little Washington, not very far from here, where the city, its Historic Preservation Commission, someone from the Design Review Committee and someone from the staff goes and says to the person, "Oh, your corbels are rotting." And they say, "I know, I've been trying to get those fixed, but I haven't gotten around to it." And then the say, well, is there any way you could get around to, let's look at it and decide what's the most important character defining thing that's falling down. They did that with the Havens Wharf, which is the first thing you see when you cross the bridge into Washington. After a while, many months, even years go by while the commission and the staff try to deal with Jeremy can't fix everything on his house this minute, but he can be helped with what is the most important thing that he thinks he needs to do, and what is the most important thing that staff thinks he needs to do, or the building inspector or preservation specialist, any of that. So that then after a while, it processes along until you have to really have a very, very important piece of historical property that the city is worth risking losing $50,000 to fix the roof, which Washington was. And then you can either let them have your property or you can pay the $50,000. But the number one thing that has to happen is until we get this in front of our governing body so that the city council can say either yes or no, we're not going to do any more than we ever have done. So I would like this to go in front of city council so they can say, wow, this is going to take a half of a lawyer or 3/4 of a lawyer and 2 extra planners. When they say that, they know that money's got to come from somewhere. And if they say to do that, then staff will come back with checking on Washington and all that stuff. But unless it goes before city council, we're going to be watching things fall off houses from now on. So I would like this to go in front of city council so they can decide rather than us, whether it's worth the city's money. Is this what the taxpayers want or not?
Yeah, I don't think it ever got that far before.
It never did.
For whatever reason, it never quite made it to council.
Never got out of the clerk's inbox on her desk.
Well, I assume obviously there's some kind of process for that. I mean, the council A is going to have to want to hear it. And then,
first, the council liaison has to make it go. And I have been assured that this piece of paper will float in front of the city council over if we get it to them.
Okay. The other thing that we want to do as we take a look around is to make sure we can make a reasonable recommendation to them, because, right now we can't, we don't know. The devil's in the details, right? Like anything else. So depending on how the process works, and, there's going to have to be fairly straightforward, laid out processes of, so when there's a complaint, what do you do? Well, like you said, you might send a staffer, perhaps it's a member of HPC. They both go out, they look around, they see what the issues are. They're going to have to write it up, and then it would come back. Obviously, conversations with that owner. Hopefully, the first attempt is to try to get voluntary compliance. But again, there's going to have to be time limits. I mean, not going to be able to wait around a year for somebody to start to do something. If you have legislation, you have some time limits in there for somebody to begin complying. And then you have to have penalties if they don't comply. And those penalties presumably, depending on council's desires, would be monetary. Just like when we find somebody that doesn't clean up their yard and they won't clean it up, we go clean it up and we charge them for it. We can also charge them penalties for not, listening when we tell them to clean it up. There's a lot of ways that people can be charged. So we have to have some kind of sense of what that looks like, because council's not going to have a clue of how to put one of these together. And that's sort of staff's job.
They'll be happy to tell y'all to.
Right. Go out and
There you
find
go.
out and come back and tell us how.
Mr. Chairman,
Yes, Mr. Casper.
do we have a motion on the floor?
Not yet.
I move that we accept the motion as written.
The resolution is
Resolution
written.
is written.
Myron, is that what you're saying?
Yes. Do we have a second?
Candace Pierce, second.
Okay, we have a motion and a second to approve this resolution as written.
My concern, of course, was that we were out of order. You don't discuss the motion before you make a motion. And I'd like to move the motion, please. It's getting late.
I was just about to call for, well, it's getting late because you keep talking about stuff that's not on the agenda. But I was just about to call for a roll call vote, please. So we have a motion by Mr. Casper, seconded by Ms. Pierce. Can we have a roll call vote, please?
Sorry.
I would like to have some discussion at this point.
I'm sorry, what was that, Mr. Casper?
There's a motion been made. There should be discussion of that motion.
Well, yes, but you just called the motion, so now I have to call for a vote.
Oh, my mistake, sorry.
Mr. Phillips, can we stop that and have discussion?
Yes, if you, essentially you're the chair and the Robert's rules are guidelines. And so certainly you can discuss that. I think that would be appropriate given the request by the member.
Okay, so in that case, we'll hold off on the call motion and we'll have discussion.
Well, it seems to me that if we don't put something before the city council, then the issues that have been raised now that we really can't determine will never be heard. So I think we ought to send this right on to the city council.
This is Andrew. I agree completely with Dr. Casper's point that we need to send this forward, and others have spoken to it. I actually just have a question about the second whereas. Is that designed to allude back to the 2013 attempt to pass an ordinance? Or is that supposed to clarify the first whereas as saying that the Historic Preservation Commission empowering sort of your enabling clause included the enactment of an ordinance or included the power to enact? I'm a little bit unclear on what the second whereas means, I guess. I'm just curious if someone can
someone read the second whereas, please.
I can read it. It says, whereas the city council authorized the enactment of an ordinance to prevent the demolition of any designated historic landmark or any building or structure within a designated historic district due to neglect. So that almost reads as if the city
they already did it.
Authorized it.
No, I could clarify that a little bit. The city in Title IX, Chapter 7, which governs the Historic Preservation Commission, gives the commission the authority to, and gives the city council the authority, which is statutory also, to make an ordinance that is an anti-demolition by neglect ordinance. That's essentially what that's saying.
Mr. Phillips, have I jumped ahead by not reading this ordinance into the record? We're talking about it, but we're implying that everybody knows what we're talking about.
Right. There is no ordinance before the commission tonight. It's merely the resolution.
Just a resolution to ask.
Okay.
Do you remember when the guy took the 17 windows out of his house and the city made him put them back and it cost him $17,000? Jeremy, you have to remember that.
I do.
That was not a bad thing for this city to do. It was the right thing to do. It did not take two whole attorneys to get that done. And it was lengthy and tedious, but it was accomplished. And people, if we ever did anything like that again, someone in the neighborhood might pay attention. So can we call the vote now?
Can I make a friendly amendment to that whereas might help clarify it? I would just, instead of saying authorize the enactment, I might just say enabled the enactment. which is a way of saying that they gave themselves the ability to enact an ordinance, right? Or maybe enact,
And just, I did find the key site there for you. It's 9-7-17 subsection C, and it states anti-demolition by neglect ordinance. The city council may enact an ordinance to prevent the demolition of any designated landmark or any building, structure, or site within a designated district due to neglect. Such ordinance shall provide appropriate safeguards to protect property owners from undue economic hardships. So that is your enabling ordinance allowing the creation of an ordinance. There's also statutory guidance for that in 160D 949 subsection B. The governing board may enact a regulation to prevent the demolition by neglect of any designated landmark or any building or structure within an established historic district. Such regulations shall provide appropriate safeguards to protect property owners from undue economic hardship. So that's, like I said, the statutory and the city ordinance authorizing, or to use, I forgot who said this, enabling the creation of an anti-demolition by neglect ordinance. I don't know if that clarifies or not.
it does, and maybe I'm being pedantic, either my years in faculty senate or living with a English professor, but it might be easier to say, whereas the city council thus authorized, because we're referring back to the original ordinance. Or frankly, we can just let it go forward and let me be a pedantic grammar police person and just let it go, because it's more important that we express the will of this commission, that we should have this investigated and hopefully enacted, than it is for me to wordsmith that whereas. So I defer to the will of the commission on this one.
We paid extra to be pedantic.
I'm sorry, go ahead, Katie.
I was just saying that we pay him extra to be pedantic.
And I was going to say that I agree with Andrew that showing our intent is probably the most important thing here. I do have one more question for Phillips and/or Barnett, and that's probably my last one. Does all the fancy legal words that Mr. Phillips just shared with us, does the fact that we're the ones recommending or asking city council to look into this, does that automatically mean that it applies to the things that we have purview over, which is College View District and local landmarks, or does that have to be added somehow?
So that would be reflected in the ordinance itself that would be recommended to council. And so one of the things to look at, as kind of as your resolution, it says at the top, to demolition by neglect of historic landmarks and structures within historic districts. And so there's only one historic district by definition in our title, and that's the College View Historic District. So it would be further reflected in the ordinance itself, but this resolution also specifies that. So.
And does that have to, here's another question, sorry. Does it have to specify local districts? Because we do have National Register District.
They do not qualify, because in Title IX, Chapter 7, I forgot the reference that's up at the top, the definition of historic district is the one that is actually recognized by council. Okay. And the only district is the College View.
Okay.
Now certainly that has room for expansion, but right now it's just the one.
Okay.
Right. Let me just follow up on that just quickly, since Jeremy asked the question. Because we're referring to the enabling language in the title of this resolution that established the Historic Preservation Commission, and not to the state statute that would enable a demolition by neglect citywide, I think this is the right resolution. And maybe Mr. Phillips will agree or disagree with that. But because we're referring back to this section, which establishes the commission that we're part of, it seems to me that the intent of that ordinance is to apply only to historic districts and landmarks, and not to citywide. So, and frankly, this is going to sound political, but and I guess I'm saying this to everyone who's watching. It's going to be a lot easier to try to do this for local landmarks and historic districts than it is to try to convince the city council that we should do this citywide. So
Agreed.
I'm ready to move forward once the rest of the commission is.
All right, has everybody had their say? Okay, so we do have a motion and a second on the floor. And that was a motion by Mr. Casper, seconded by Ms. Pierce, I believe. Did I
Yes,
remember
sir.
that correctly? Okay, so can we have a roll call vote, please?
Yes, sir. Jeremy Jordan,
Aye.
Candace Pierce. Candace Pierce,
Candace Pierce, aye.
Andrew Moorhead,
Aye.
Israel Mueller,
Aye.
Myron Casper,
Aye.
Scott Wells,
Aye.
Justin Edwards, Carrie Carlin,
Aye.
Robert Wright.
Aye.
Mr. Chair, the motion was approved unanimously.
Thank you very much. And so at this point, we wait to see what city council does with it. Am I correct?
You have to sign it first, Jeremy. That's important.
Yes, we take it over to the manager's office and proceed to get it on the agenda.
Yeah. Okay. So now, once I sign this, who do I need to scan it to? Shantae or?
Shantae or Tony?
Okay. All right. Perfect. All right. So that takes us to our public comment period. Madam Clerk, do we have anyone sign up to address us tonight?
No, sir, we don't.
Okay, so I won't read through all the lengthy regulations about the public comment period then. But I will say that we have 30 minutes allocated at each meeting for people to address us for up to 3 minutes apiece about any item that is not the subject of a public hearing at the same meeting. And now we are down to committee reports. We've already heard about the design review committee's work. Publicity and selection did not meet this month for a couple of reasons, one of which that several people were not available. So we do need to get those committees a meeting. That takes us down now to the approved COA and minor work COA staff update.
Okay, Jeremy, this is the latest table I've created. I was out with a little issue for a couple of weeks. So I'm a little behind schedule on taking pictures going out in the field. This is what I have for you tonight. There are two that are complete. I'm going to show you which ones they are right now. This is my list that I'm working off of. I've got to go back and tweak it a little bit. 401 Student Street was painted with light color. That's complete now. And the other one that's coming off is 405 Jarvis Street. They repaired some wood rot and touched up paint with light color. And that's it for my staff update.
Okay, do you have any questions about that? All right, seeing no questions, we'll move to our next item, which is announcements and other. Does anyone have anything to share with the commission? No? In that case, we come down to adjournment. Does anyone have a motion to adjourn?
Candace Pierce, move to adjourn.
You have a motion by Ms. Pierce. Is there a second?
Second, Scott Wells.
You have a motion by Ms. Pierce, seconded by Ms. Wills to adjourn. Can we have a roll call vote, please?
Yes, sir. Jeremy Jordan,
Aye.
Candace Pierce,
Aye. Candace
And-
Pierce.
Andrew Moorhead,
Aye.
Israel Mueller,
Aye.
Myron Casper,
Aye.
Scott Wells,
Aye.
Justin Edwards,
Aye.
Carrie Carlin,
Aye.
Robert Wright.
Aye.
Mr. Chair, the motion to adjourn has been approved unanimously.
Thank you. We stand adjourned. Everybody stay safe.
Thank you.
Thank
Good
you.
night.
It's good to see all you.